ready?
We welcome you all to the 4th AIU National Moot Competition 2025. This is our final round. Here are some rules. Here are some rules which shall be followed by everyone. Use of electronic gadgets is strictly prohibited. Time limit for final is 50 minutes per team, in which speaker shall speak according to their discretion. But neither an individual speaker shall be permitted to speak more than 30 minutes, not less than 20 minutes. This 50 minutes time limit is exclusive for the time allotment for rebuttal and sub-rebuttal. Time limit for the rebuttal and sub-rebuttal round is collectively 16 minutes for both the teams, which is further divided into 8 minutes for rebuttal, and if the judge permits, then 8 minutes for sub-rebuttal. Time stamp will be shown in the remaining of 20 minutes, 15 minutes, 5 minutes, 2 minutes, 1 minute, and time over of every speaker, according to the time taken by the speaker. If in case of any disparity, decisions of judges shall be final and binding. If the honorable bench permits, we shall begin with the final round.
May it please this honorable court, at the outset, this honorable court before I approach the dais. Actually, yesterday, accident, our auto toppled over, owing to which I have knee injury. Although it's not major, but I have sufficient inflammation there. So I may lean a bit or take support. I must request that this court not consider this as disregard of the court etiquette.
Even in actual courts, in case the lawyer is having some difficulty, we permitted lawyers to argue while sitting.
Certain introduction. Actually, there is a section of marks in this court etiquette. Please don't deviate from the permission to approach authorized.
And in case you are also not comfortable, while standing, you can also sit down.
I can stand in my position. I would not want the mic. Can I argue without the mic? Much obliged. Lordship, I am the counsel appearing on behalf of the petitioner Kaveri. I will be representing the petitioner for the first two issues. I am assisted by my co-counsel. She is representing the same petitioner Kaveri, but with respect to the third issue of PIL and issuance of guideline. We are assisted by a researcher. We collectively form the council of petitioners. Lordship, this is a case between two magazines which has been coming forward since ages. One being ex actio et bono, the law of fairness, justice and equity, and the other being verbis legis expressis non est residendum. That is, the plain language of the law must not be receded from. This is the common theme which runs through all the three issues, my lordship. And we have, this court has time and again prioritized the first magazine over the second, as it is the first which is the soul to the dead and plain body of law. To quote the case of Maneka Gandhi, we abandoned procedure established by law and breath sold into it by following the due process of law, lordship. Now, having given some context to the issue, I would address the issue straight away with my lord's permit. Can I leave out the facts and address the issue straight away?
Yes, sir. Again about the brief facts.
Brief facts. Certainly, lordship. The petitioner in this case is an aspiring, dedicated, earnest, diligent dancer. She applies for a scholarship to which she is very much eligible, but she is denied. The selection committee denies or rejects her candidature on certain grounds which were added upon later, which didn't form part of the initial notification. And an attempt has been made to make it fall under one of the clauses, but that is forcible attempt. And she has challenged this first round of litigation, begins with the High Court. Two independent cases have been filed, one being the writ petition, the other being the compensation suit. Now, the writ petition was dismissed based on closure report of the police. I will highlight the discrepancy in the same and how that judgment is untenable. And the second, so far the suit is concerned, lordship, that was never appreciated independently. On the basis of the concurrent bench's decision, the suit was dismissed. And as she had no other recourse other than to reach this honorable court by way of an SLP, and later she has also filed a PL, both of which stands club by virtue of this court exercising its powers under Article 139 lordship. This is the brief facts. May I please address the issue? Lordship, the first issue deals with the validity of the rejection, lordship. I will be advancing my arguments under 4 prongs of submission. I have noted it in my memory. We have mentioned it in the memorial as well. I will be submitting in between 3 cases as well to support my argument. Lordship, Lordship, my 4 prongs of submissions are: absence of questionable social media posts as a condition in limine. They were not a condition to begin with in the notification advisory. You will note that in the notification advertisement, this is not a condition nowhere mentioned in the Moot prong. And the second is, I would refer their lordship's attention to page number 2 of the Moot prong, para number 3. The applicants for the fellowship undergo a stringent scrutiny prior to their selection. That's the paragraph. Lordship is referring to the memorial. I intend for you to refer to the Moot proposition.
The Moot.
I have it.
Yeah. This one.
Yeah, this is the Moot proposition. Second page, para number 3, Lordship. Nowhere is it mentioned that absence of questionable social media post is a condition in limine. Now, Lordship, I rely on this judgment of Tej Prakash, a recent judgment of this Honorable Bench, Honorable Supreme Court, in which it has been explicitly said that rules of the game cannot be changed midway. Once the ball is set rolling, rules are set, you cannot change the selection rules in between or add any new rules. And that is the judgment I rely upon to support my contention. Now, Lordship, so far as the second prong of submission goes, Lordship, I am advancing the argument that the select committee, which is Prava in this case, is it the right authority? It's an expert body for the purpose of selection of the dancers. Is it the...
Yes, sir. The rules of the games have been changed midway.
Yes,
so
sir.
they take into consideration her social media post.
Yes, yes, sir.
Suppose this is the other terms and conditions of her application.
Yes, sir.
Supposing she was having some criminal case against her. This is also not been mentioned out here.
Yes.
So, and the selecting authority takes into consideration the criminal case which is there, or
Sir.
for that matter, conviction in a criminal case, although not specifically or categorically mentioned in the terms and conditions. Would this judgment still come to your
Lordship, so far as...
would it amount to changing the rules of the game?
Lordship, since...
Was there has been a concealment?
Not at all, Lordship. I will...
Because this is not explicitly indicating the argument.
I understand.
Would that amount to changing the rule of the game? If that is considered.
I understand your Lordship's question, but Lordship, first off, she doesn't have any criminal antecedents. And second off, Lordship, there are few judgments of this Honorable Court which clearly state that merely having criminal antecedents, acquittal, it could be an acquittal. We do not know what happened in that case. So all those considerations also come into play, Lordship.
So these are the terms and conditions
Yes.
of her application.
Yes, Lordship.
Now they consider her social media post
Yes, Lordship.
a ground to cancel a candidate.
Yes, Lordship.
Not consider. You say that it would tantamount to changing the rules of the game.
Yes, Lordship. I mean...
Because that, according to you, tantamount to changing the rules of the game, because that condition was not specified.
Yes, that's...
So therefore,
Yes,
for a minute, if that social media post we do not consider that,
yes, Lordship.
supposing there was a criminal case against her,
Yes, Lordship.
and the selecting committee considers that criminal case, that is not mentioned in the advertisement.
Yes, Lordship.
So would that consideration of the criminal case and rejection of a candidate would that also tantamount to changing the rules of the game?
Lordship,
Or it goes without saying that a candidate to be selected should be fair and
should be fair.
honest.
I agree with their Lordship's point. And moreover, so far as criminal antecedents background check is concerned, this court has upheld its constitutionality in numerous cases, one major being PUCL and all these cases. But until today in India, this court has never had the opportunity to consider the background checks outreach constitutionality per se. There is one case, NASA versus Nelson, but that is US Supreme Court case, that upheld the background checks as constitutionality, but this court had never had the opportunity to check that matter. So, my Lord, may I proceed with my submission? My Lord, why I say is the condition on which she has been rejected, alleged condition is, she is not fit to be a brand ambassador. That was the response given by Prava. Now, my Lords, in the notification, they have simply mentioned capable of being a brand ambassador. What are the entitlements? What are the disentitlements? How long would it have taken to add 4 to 5 more lines prescribing when will you be perceived, deemed to be capable of a brand ambassador? Devoid of that, this is a discretion, and whim and caprice comes into play. Anytime any condition may be required for being a brand ambassador, and I state this with certain evidence, even in the Rajya Sabha question. Could I request one of you to stand here? You will note it's a unstart question of Rajya Sabha. One member asked the ministry, there is no transparency on who should be appointed as brand ambassador. And Article 309, if you may refer to Lordship, clearly says that it involves not only its public post and connection with the affairs of a public post to a union or state. Now, brand ambassador's post will fall squarely under connection to the affairs of the union. And as such, public post, its public confidence and disclosure should be made. What are the entitlements and disentitlements? So here, in absence of it, discretion is involved, and as such, non-arbitrariness comes into force. And in the famous case of, I will refer to one case as well, a state is supposed to be a model employer, Lordship, and it is bound by Article 14 and 16, the equality clauses, which in the new dimension, arbitrariness and equality are antithesis to one another. And here, arbitrariness exists. Now, this brings me to the second prong of submission.
You refer to Article 309, this refers to a public post.
309, yes, Lordship. Yes.
This refers to a public post.
Lordship, in this case it is, because she is brand ambassador to Ministry of Cultural Affairs. So it's a public post, connection with the affairs of the union. So it has some connection with the affairs of the union, Lordship. So as such, it's a public post. And I will establish that how this Prabha is a state in accordance with Ajay Asia and Pradeep Biswas case. I will also establish this in my subsequent
Will be person appointed in this Ministry of Culture?
Yes, Lordship.
He would be holding a public post.
Certainly, Lordship. As a brand ambassador, if he is appointed, he is accountable to the, it's a public post, Lordship. Because again, it says that it is a broad conception, connection with the affairs of the union. I am stressing on those lines. On that basis, I am saying that it will fall under the ambit of the same Lordship. No, Lordship, was Prabha the right authority? This brings me to the second prong of submission. To decide on the question of whether the video was a deepfake or not. I draw your attention to page number 4, para 3 of the Moot proposition. Line 2, if you note, Lordship. Page number 3, para 4, line 2.
Page number 3.
Sorry, page number 4, para 1. They also refuse to accept it as a deepfake case, as no obscenity is seen in those videos. If my Lordship, I have their Lordship's attention there. There is no page number as such, but I am referring to on the basis of number of pages. Fourth page.
They refuse.
Fourth page, first para. They also refuse to accept it as a deepfake case, as no obscenity is seen in those videos. And as such, no, Lordship, deepfake need not always involve obscenity. Now, I understand there are no experts on law. What is the definition of deepfake? But any common person goes to a dictionary, basic lexicon, to refer to the what means what. If you note in our memorial, petitioner's memorial, if you have, Lordship, in page number 21, I have written, not 21, Lordship, 20. I have written what is the Merriam-Webster's definition, no, 21 only, para number 21, page number also 21, Merriam-Webster's definition of deepfake. Lordship may please go through. It has got nothing to do with, it simply says that doing a manipulation of something said or done, otherwise than something in actuality what was said or done. It has got no relation with obscenity. That definition of deepfake and equating it with obscenity as a necessity, Prabha is not the expert on that point. And as such, this decision is arbitrary. And my Lordship, I will also address you on the third prong of submission, test of arbitrariness. Two prongs we apply: reasonableness and then nexus, rational nexus with the object which has to be achieved. Reasonableness, there is no reasonableness. This decision itself, this one para goes to prove my point, Lordship. And as such, first prong fails and there is no call for applicability of the second prong arises as such. Now, it also fails the test of manifest arbitrariness. Manifest arbitrariness, as defined in Indian Express and also in Joseph Shine and other cases which follow them, is as anything which is out of whim, caprice, inadequate consideration. All these three things are there. Out of whim and caprice, they said that obscenity is a necessity for deepfake, and out of what considerations is given? No adequate considerations were taken, not even a basic dictionary. So as such, both the tests it has failed. Now, last prong of submission, Lordship, mine is that usually in these cases we apply the proportionality test, but this is not the same as one in Kutaswamy, but it's a different test. We look balance two interests: the necessity to preserve the sanctity of the selection process vis-a-vis the prejudicial impact of the decision taken by the select committee on the candidate, Lordship. Now, Lordship, the necessity of the preservation of their already the sanctity has been ruined. My Lordship will note in a certain para of the Moot prop that breaches have occurred from the server. So already the sanctity has been compromised. So what can be saved now? It is the other side, the prejudicial impact that it has on the candidates. And I also rely on one of the cases in the same judgment, Vashish Narayan. This case, this court in several cases has let the candidate proceed further when inadvertent errors were made by him, like in not marking the OMR properly. All these were inadvertent errors, and this court held that it should not have a prejudicial impact on the candidate. In our case, is the petitioner anywhere at fault? As such, my Lordship, she should be given benefit of the same. If I have satisfied their lot, and I will also take you to page number 22 of my Moot prop. I refer to the US position on such. What is the law when it comes to social media posts? Can you reject someone on that basis? I am sorry to say this, Lordship, but Indian, there is no Indian case on these points. Lordship will note that I have referred to a legislation in my memorial, page number 22, Fair Employment Order. It's a US Act. Now, according to it, you cannot reject someone on the basis of their political opinions or opinions they keep. Now, I have also quoted many cases in which such a rejection was overturned. I have explicitly quoted a case which has some relevance to the case at hand, which is the McLean case, McLean versus Waterside Neighborhood Partnership Limited. In this also the facts are similar, Lordship. A candidate scores the highest mark, but is still not selected because of the comment he makes about the community. He says, all that he says is, the community should own the resources and not the government. For this one remark, he was rejected. If we accord such right to reject people on the basis of social media posts, then it is unfettered, Lordship. It will be, currently labor laws follow something called equal balance, tripartite system. That will disturb the balance. We will be putting the employer at a higher pedestal than the state and the employer. This is one of my submissions.
We just indicate one.
Certainly, Lordship.
Privacy, this could be. There's a rise on Article 309 to indicate that she would be holding a public post.
Yes. No, Lordship. I indicated public post in connection with the affair.
Then if there's a no fair employment treatment order 1998,
yes,
indicate that the social media post should not be used in order to deprive her of being appointed
yes,
as the brand ambassador.
Yes, Lordship.
Now, those social media posts are reflecting, not in this particular case, but we would be reflecting the mindset of that particular individual.
Yes, Lordship.
Now, knowing fully well that mindset, can you still say that whole media post or that mindset should not be considered while appointing a person on a post? Because he would perhaps still continue with that particular mindset.
Maybe, Lordship, but what if he doesn't continue with that mindset? Maybe back then, yes, people learn and grow, Lordship. We cannot penalize them for their past actions. And she said it in our case, when she was 17 years old. Currently, she is 29 years old, Lordship. So she has grown. Vast majority.
You know, minor
besides,
Lordship. It's not indicated. It finds place in this right now.
Yes, it is in the proposition. 17 years old, she is a minor. And what is this statement she makes? In a debate competition, wherein we are forced to take sides and say things which we are not convinced of. So what if she said it not being convinced of it? Because she had to say it to defend her side. And what she said does not in any way demean a country. You will note that it's a community in a country. Sakimala is a community in a country, Lordship.
Slightly missed out one thing. You have indicated that at the time of her media post, she was 17.
Yes, Lordship. I was coming down to that, Lordship. My Lordship asked me to state it earlier, but I was certainly addressing this.
Notice and in these right over.
Actually, I was coming down to
those are the things that should be indicated in the argument.
I was coming down to that. Yes, Lordship. First off, she was 17 years old, and it was a debate competition wherein we are forced to say things which we are not convinced of. These are some points, and there is a gap of nearly a decade or two. So as such, she cannot be penalized for past actions. And besides Lordship, it's the Prava's own failure, the committee's own failure. Now that brings me to my second issue, if I may be allowed to address my argument on the second issue. And Lordship, I want this court to take note of the Renu Sharma case which I submitted, applying the test of proportionality, necessity to preserve the selection process vis-a-vis the prejudicial impact of the candidate. In this case, the other prevails over that. Now, in the second issue, I will be advancing again under two prongs of submission. My first contention is the High Court did not exercise this.
What is the second?
Second issue is whether Prava is liable to pay compensation to the petitioner Kaveri. This is the second issue, Lordship. Now, my Lordship, my first prong of submission is that High Court did not exercise its jurisdiction in its widest parts. It didn't exercise its 226, it was filed under what an High Court does in a 226 petition, Lordship. I am submitting a case for your perusal. State of Andhra Pradesh versus Sri Rama Rao, in which one question which is asked by this High Court is whether the authority which took the decision, did it examine that the authority's authority to take the decision. I submitted the case. In our case, did the High Court even consider the possibility that Prava is not the right authority to take any decision on whether the video was a deepfake or not? This should have been done by the High Court, but it missed on the same Lordship. Now this brings back to my argument. I will be establishing breach, and let it be noted, Lordship, that I am not merely claiming compensation for the breach, but also breach of certain principle called storage limitation. I will take my Lordships to the same, but prior to that I am bound to establish that Prava is a state. If I may request your attention, I am submitting the DPDP Act for your perusal. I have flagged the necessary sections that report to be seen, Lordship. The necessary sections are 2I, read with 2S. First, in 2I defines the data fiduciary and it uses the word person in it. And 2S defines what a person is. And 2S clause 6 says person includes state. Now, Lordship, I also submit for your perusal two cases. The recent Rajkaran Singh case, in which AEGIS and other state tests, instrumentality test was considered, as well as Pratik Biswas. My Lordship will remember that in AEGIS 5 tests were laid out for determining what is the state. First two being extent and control test, the last three being the functionality test or instrumentality test. Now in Pratik Biswas, the court went one step ahead to say, or to rather clarify, that all the tests need not be fulfilled, but overwhelming fulfillment would be looked at. And the right test is that three words were used, Lordship. In truth owned by government, in fact funded by government, and in effect an incarnation of the government. All of which is Prava. You will note it is funded by the government and it is performing a function which ideally a government does. 309 clearly confers upon the government the power to do appointments. And that has been given to Prava, and as such it is carrying out a government function and rightly falls under Article 12 state, as well as 2 clauses read with clause 6, it is a state Lordship. So if I am satisfied that Prava is a state, now Prava is a data fiduciary as well. 2I.
What is Prava?
Prava is a select committee, Ras Nritya Prava, full form, but shortly referred to as Prava. It is the select committee which is selecting the candidates. My Lordship, now if you refer to 2 clause I, data fiduciary includes any person and Prava is the data fiduciary. And data principal in the current case is the petitioner Kaveri. Please refer to DPDP Act, that is the Act, Lordship. Please refer to section 8 of the Act. It is very crucial that their Lordship have the same, because I am going to advance a very crucial argument. Section 8, Lordship, you may have that. That is also the DPDP Act.
we are 2020.
Yes, yes, 20. Now, Lordship will note there that 8 clause 7 in particular, the obligations of a data fiduciary. Now, the argument which a respondent would make is we do not have a duty. 8 clause 7, please note, Lordship, 8 clause 7 clearly imposes data protection. 8 clause 7, Lordship. 8 clause 7 A, clause A. 8 clause 7 says a data fiduciary shall, unless retention is necessary. They have also flagged it in the memorial. You may refer to the memorial as well. Page number 26 of the memorial. If you will find that a data fiduciary shall, unless retention is necessary for compliance with any law for the time being in force, erase personal data upon data principal withdrawing their consent, or as soon as it is reasonable to assume that the specified purpose is no longer being served. In our case, Lordship, the purpose behind the video being in the server in the first place was for its examination for the purposes of selection. Now that stood exhausted the moment the video was examined and decision was taken. After that purpose being exhausted, why was it retained in the server longer? It is a breach of this principle. Now they can't even claim any exemption. 17 clause 2 and 17 clause 4, if you may refer to. Section 17 of the same Act, clause 2 and clause 4. Lordship may refer to 27 of the Moot memorial as well. You will note that in 17 clause 2, it's an exemption. First it says the provisions of the Act shall not apply, necessary for research and all this, is not to be used to take any decision specific to a data principle. In this case, the data, the video, was specific to the data principle Kaveri. As such, the exemption goes out of bounds. Now, 17 clause 4 again imbibes the same principle. So, no exemption also can be claimed by the state lordship. So, as such, now I will establish breach. Lordship, may I establish the breach now? Please refer to page number 4, para number 3 of the Moot proposition. If my lordship have it there. Fourth para, second line. The video was similar to the one which she sent to Prabha on the given link, but it was a morphed video. Now, lordship, the video which is being alluded to here is the video which Prabha uploaded on the server, in the video which Kaveri uploaded on Prabha's server, which was subsequently leaked and made a deepfake of. Now, my lordship, this is a civil case, and the right burden of proof is preponderance of probabilities. Now, this goes in my favor. There is a breach, and the video which is uploaded is the same as the video I uploaded on Prabha's server. I have established a causal link on the basis of preponderance of probabilities, and I am entitled to compensation, lordship. I will wind up by arguing under the whether I am entitled to compensation or not. Lordship, first off, I would like to refer to one of the cases of the US. Although it's a district court case and has no binding, but owing to paucity of such cases, I have to refer to this. In this case also, for the very principal's breach, the breach of the principle of storage limitation, which I just took the laws through, the petitioner in this case was awarded compensation. Ring LLC, what had happened in this case, the Amazon, one of the employees of the Amazon, CCTV camera, he retained the videos and retained them and used it for wrong purposes, unlawful purposes, and as such, compensation was awarded, merely on the basis of breach of the storage limitation principle in this case. My lordship, if I am to claim compensation, the only remedy which the legislation has left to us is to claim it by virtue of a public law. Because lordships, if you note section 44 of the DPDP Act, clearly omits away with the only existing provision of compensation in the current realm of technology legislation. DPDP Act, lordship. The digital data, personal data, sorry, my apologies. 44, section 44, it does away with 43A of the API. 43A provides for compensation for breach. It has done away with it, although it deals with the corporate body only, but compensation has been eliminated. Now, Lordship, PDP Act. PDP is the personal prior to the Data Protection Act, which was first draft. In that draft, they had a compensation provision under section 64. Now, they have not incorporated it in the DPDP Act. Now, as such, I am left with only one remedy to approach this court under public law. Now, I am relying on few cases which will bolster my submission. These are landmark cases: Neelabati Behra, D.K. Basu, and Subhe Singh. Also referred to the Rudul Shah and other cases. In these cases, it was clearly said that whenever a fundamental right is breached, Article 21 was alluded to. Just 2 minutes, I will wind up my submissions. Article 21, fundamental right is violated. The person will have a public law remedy, irrespective and not in prejudice, without prejudice to whatever remedy, other remedies he may have. Now they have shut up the doors of compensation for me. Now it is upon the court to open it and enable me to get the compensation. Now which right am I alluding to here? What is the fundamental right? Article 21 also includes right to privacy as a fundamental right, as held by the Supreme Court, this Honorable Court in Justice case, Kutaswamy's case. Now fundamental right comes attached to my case, and as such I am entitled to compensation under public law remedy by virtue of these cases which I have relied upon. Now I would like to wind up my conclusions. I have also referred to one of the CJU's case, Court of Justice of the European Union, Thomas Bendel's case, in which compensation was awarded for such a breach. Lordship, now why has the legislature penalized and has done away with the compensation as a whole? This is not something I can inquire into, but this court should, Lordship, because you cannot do away with the remedy. Whether it is first of the legislature is entitled to, and this case is landmark in many respects. If this court decides to pass the guidelines today, this will be the first case of techno or digital judicial activism, Lordship. And landmark, because this will be the first case in which this question will be asked. Does the Parliament have the right to do away with one of the remedies altogether? It will be landmark in this respect as well, Lordship. That would be all from my end. I would like to invite my co-counsel to argue on the third issue. So the pleasure arguing for this matter.
The council seeks permission to approach the dais. Greetings to the honorable bench. This is made to the bench. This is counsel appearing on behalf of the petitioners. This is in relation with the PIL that was filed in this show. My lord's comment, I would write on this application. My lord, the issue says whether there is a need for this Honorable Supreme Court to issue guidelines for the regulation of AI in general and deepfakes in particular, my lords. My lord, Fiat Justitia Ruve Calium, which means let justice be done, though the heavens fall. My lord, now this is a fit maxim for the case, which is the present case in our situation, my lord, because what we seek is absolute justice. So, my lord, I would be submitting my argument based upon 4 lines of submission. One is the absence of an existing legislation that deals directly with the issue. Secondly, a marked proliferation in the cases of deepfakes in the recent years. Third, the duty of the state to comply with the DPSPs, in this case, Article 51 of the Indian Constitution. Now, this would be corresponded with the blessed declaration that Tirupala is a signatory to. And the last one being necessity to secure complete justice under Article 142 of the Indian Constitution. So, if my lord's comment, I would be dealing with the first line of submission. My lord's absence of an existing legislation that deals with the issue in particular. My lords, currently in the country, we do not have any specific legislation that is dealing with the issue of AI data movement tools, which include the deepfakes. My lords, what we do have is fragmented provisions from various acts which the state is trying to put together to try and handle this issue, but it is simply submitted that these are highly inadequate. I would be establishing the same by going through Technology Rules of 2021, my lords. This is in correspondence to the advisory that the Union Government issued in 2023, in November 2023, my lords. This is an advisory, this is issuance of guidelines to the social media intermediaries, my lords, do not post such content, to remove such content when it is reported, and to take action against such content. My lords, now the lacuna here is that there is no safeguard that exists before the content is removed. Also, my lords, it puts an undue pressure on the social media intermediaries. It is true that they have a responsibility to take care of this, but this is not their sole responsibility to take care of this issue, my lords. The state is entirely doing away with the responsibility. My lords, also, if it were actually helpful, there wouldn't be a marked high proliferation in the cases, and the cases are only growing on the contrary, my lords. Now, my lords, I will be going with the second legislation that we have. It is the Information Technology Act of 2000, my lords. Now, my lords, from this act, we have taken up several sections: 66D, 66E, 67, 67A, and 67B. If my lords could go through the IT Act of 2000. My lords, these are the offences that deal with impersonation by cheating, violation of privacy, transmission or transmitting and publishing of sexually explicit content, my lords. Now, my lords, these are the sections that have been applied in such cases of deepfakes and AI, my lords. But the lacuna, the major lacuna here is that they do not, none of these sections do not directly correspond to the issue of deepfakes, my lord. It leads, as my lords would be well aware, it leads to a lot of ambiguities, it leads to a lot of loopholes that the misusers can use, my lord. Also, it does not deal with the issue. Nowhere in the act is it specified the word deepfake, the word AI. Nowhere in this entire act, my lords. So, my lords, the lacuna has been established in this act as well. And now I would be moving to the DPDP Act, the Digital Personal Data Protection Act, my lords, of 2023. This is the most recent legislation that they have come up with, and it deals with the protection of personal data, upholding the privacy rights, etc. Now, my lords, it is very important to note. I request my lords to go to section 3, clause C, clause 2. My lords, it very conveniently leaves out the publicly available data, my lords. It does not cover under its protection, the ambit of its protection, the publicly available data, the data that the users have intentionally made available into the public domain. Such is the case of Kaveri, my lords. All the social media influencers, all the public figures who have their data uploaded on these social media apps, my lords, their protection of their data has been conveniently done away with. So, my lords, this is a major lacuna which conveniently does away with the protection of publicly available data, my lords. So, my lords, it is humbly submitted, and that these legislations that have been used are not sufficient, that are nearly sufficient to suffice with the current issue, my lords. Now, if my lords are suffice with the first line of submission, I would be moving to the second line of submission, which is a marked evolution in the cases of deepfakes in the recent years, my lords. As my lords would be very well aware, the issue of deepfakes is on a high rise. I would like to submit this for my lords for review. My lords, this is as of June 2024. According to a survey by McAfee, more than 75% of Indians have been in contact with some form of a deepfake content in the past 12 months, and over 38% of them face some sort of a deepfake scam. Now, my lords, the deepfakes are not limited to the mere misuse of deepfakes. They translate into much severe issues as well. For example, financial risks. For example, gender inequity issues. For example, political risks. Now, my lord, these risks are more evident, and they are also on a high rise day, but as my lords would be very well aware, I would firstly cite the financial risks. According to a study by the University of Baltimore.
Does any act define deepfake?
No, my lords. My lords, the financial risks I was talking about, the University of Baltimore, alongside a cybersecurity firm called Check, has published a study where it says that in the year of 2020, the global economy lost almost $78 billion due to misinformation, my lords. And as we all know, that deepfakes and misuse of AI plays a huge role in the spreading of fake news, my lords, misinformation. Also, coming back to the McAfee report, my lords, I would say that more than 83% of the AI scammers, the victims of AI voice scams, they use voice cloning, the deepfake AI scammers. My lords, 83% of the have been in contact with them have faced monetary losses, and more than 48% of them have lost more than 50,000 rupees, my lords. Now, considering our population, our economy, this is a huge amount, and this is happening day by day, and the actual figures could actually be much higher. My lord, I would cite an example. This is from a established newspaper, national newspaper, my lords. I would give an example. In New Delhi, there was a senior citizen. He receives a phone call saying that they are the kidnappers and they have kidnapped his nephew, and they coerced him to pay 50,000 rupees through Paytm. He did the same. He was panicked. He did the same. He made the payment, and later only to discover that his nephew was never in danger at all. The myth.
Why are these instances required to be indicated? Why are these instances required to be indicated? How is it relevant?
My lord, I am really pointing out to how deepfakes are translating into severe other issues, my lord, such as financial risk. The countries right now, this is a public interest litigation, my lord, so I am bound to submit that. Also, my lord, the gender inequity issue. We know the infamous case of Rashmika Mandana. This is in India, and as per the study of an Amsterdam-based firm called Deep Trace, more than 90% of women are the victims of deepfake pornography, my lords. This is further increasing the gender inequity, which is also a serious issue, my lords. Now we have the political risks. My lord, I have also mentioned in the memorial, but I would cite another example. Recently, a deepfake video of our Honorable Home Minister was leaked, my lords. Now, my lord, such distorted speeches, distorted videos, images. Now, my lords, this is in the context of Tirupala. My lords, people here are not literate enough, they are not aware enough, they can't differentiate between what is a deepfake and what is authentic content, and this is leading to political polarization, which we cannot afford in our country, my lords. This is leading to public distrust, public animosity, my lords. Now, my lords, and this is not the only PIL in this issue. We have the PIL of Rajat Sharma versus Union of India in the Delhi High Court, but my lords, the issue is still the same. My lords, now I would be furthering with the third line of my submission, which is, my lords, also for the reason for the gender inequity issue, I would like to submit a snippet. My lords, my lords, if my lords permit me to move forward with the third line of submission. Now, the duty of the state to comply with the DPSPs, in this particular case, Article 51, in correspondence to the Bletchley Declaration, my lords. Now, Article 1, I am presuming that my lords are very well aware with the provision of Article 51, but I will still mention it. Article 51, promotion of international peace and security. More importantly, I will be highlighting the second, the C clause, foster respect for international law and treaty obligations in the dealings of organized peoples with one and another. My lords, this clearly mentions the state has the duty to comply with the international laws and treaties that it is signatory to. And my lords, the Bletchley Declaration corresponds to the same. India or Tirupala is a signatory to the Bletchley Declaration. And now, my lords, I would like to cite a principle, pacta sunt severanda. Pacts must not be severed, my lords. Now, this principle has to be taken into account. My lords, the Bletchley Declaration clearly states two agendas. Firstly, to identify the AI-based risks, and secondly, to formulate cross-country policies to deal with the same, my lords. But no such progress has been done on part of Tirupala, where there is a desperate need to do so. My lords, I would be submitting a few case laws on the same. The case of MS Entertainment versus Super Cassette Industries. The Gramophone Company versus Virendra Pandey. And even the case of Shahu versus State of Rajasthan. My lords, in the case of MS Network versus MS Super Cassette Industries, the court had laid few grounds for which the adoption has to be done, my lords. I would be highlighting the relevant provision of this. To fulfill the spirit of international obligation which India has entered into when they are not in conflicting with the existing domestic law. No such domestic laws exist in the first place, my lords. Now, my lords, the Bletchley Convention, as I've already established, sets out the same. My lords, in the case of Vishaka also, the CEDAW was established in Indian law, but no such implementation of the Bletchley Declaration has been done. Also, in the case of Neelabati Behra, the ICCPR was followed. In the case of Chairman Railway Board versus Chhatrapati, the principles of the UDHR was followed. But no such following of the current declaration has Laborments versus Union of India, the landmark case, the DPSPs were actually put on a higher pedestal than the fundamental right, my lords. So it is essential for the state to comply with the provisions of the DPSPs in this case, my lords. Further, my lords, I will move in with the last line of my submission, which is the invocation of powers under Article 142 of the Indian Constitution to secure complete justice. It relates to the maxim that I stated in the initiation of my statement, my lords, that we need to secure complete justice. My lords, absolute justice is what we need, and this honorable court has been vested with supreme powers, my lords, to do the same. And this is not just for the case of Kaveri, my lords. This is a public interest litigation. We represent the interest of the whole of the country, my lord. And as I have already established, the issue is rising day by day, my lord. There is a desperate need for a legislation, for the court to issue guidelines on this matter, my lord. And now, my lord, for the help of the court, I have proposed some guidelines which the court can issue in all my humility, my lord. These are techno-legal guidelines that I would like to submit. First is the watermark technique, my lords. According to technicians, technical experts, and according to legal advisors also, this is a very efficient method. My lord, I would submit an example of what watermark looks like. It is displayed in the background of a deepfake content. Now, when a watermark has been put on a deepfake content, now the users can identify whether this content is authentic or whether it is, and it also leaves an invisible digital signature. So it can be traced where the user has manipulated the data, my lord. Second, we have the blockchain technique. It creates a blockchain, an immutable blockchain. Now, when the blockchain is established, we can trace where the data has originated, where the data has been manipulated, and how it has been transmitted, my lord. So it becomes very easy for the state to trace who is responsible, my lord. Now, security protocols. The court can issue multiple security mechanisms. What is needed in the current case, my lord. It would require a lot of security measures to ensure that this issue is handled. Currently, there is no security protocol. Also, the use of deepfake detection tools. Like deepfake is an app, like by the use of applications, you can process data to create deepfakes. There can also be anti-fake apps, which can deprocess the data to identify what the actual, like in the case of Kaveri, it was required to find out whether this is a deepfake or whether this is not. Also to follow the 5-pillar action plan, which is detection, preventing spread, strengthening the reporting mechanism, grievance appellate system, and also spreading awareness, which is basic, my lords. My lords, I humbly end my submissions here, and I would request my lords to permit me to proceed with the prayer. Wherefore, in the light of the facts stated, issues raised, arguments advanced, authorities cited, it is most humbly and respectfully submitted before this Honorable Supreme Court that it may be pleased to hold the rejection of the petitioner's candidature unjustified and order a selection or order for a reselection which is devoid of the consideration of a questionable social media person. Also, order the payment of compensation to the petitioner to the tune of amount that it court deems fit. Also, issue guidelines for curbing the menace of increasing cases of deepfakes in the country, and or pass any other order, decree, direction, or relief that it may deem it in the best interest of justice, fairness, equity, and good conscience. All of which is humbly prayed, my lords.
Why did you not disclose the amount which you want to pay as compensation?
My lords, the initial ask for the amount was 5 crore rupees, but we are leaving it to the discretion of the court how much the court deems to be. It was a pleasure attending to this court.
It is quantified. 5 crores, how have you quantified that amount of 5 crores? Why not more than that? Why not this and that?
Well, this is the exact amount that the petitioner would have been otherwise gotten if she had secured the fellowship and thus the amount she has suffered, my lords. This is a strict relation, not more, not less, my lords. Most of that.
The council seeks permission to reach the dais. Much obliged. The council seeks permission to refer the bench collectively as a lordship. Much obliged. In the present case, the council is appearing on behalf of the respondents, that is Rasandil Prabha versus and Union of India. There are a total of 3 issues. The first issue will be addressed by the first council and the latter 2 issues will be addressed that the rejection of Ms. Kaveri's candidature for the Kala Padmati Bhakti Fellowship was legally justified, procedurally fair, and in complete alignment with the fellowship's objectives. The selection process was based on expert evaluation, adherence to defined eligibility criteria, and a transparent procedural framework. The first issue which the article is discussing is whether Ms. Kaveri's rejection of candidature by Trevor on which the social media post is justified or not. It is humbly submitted that Prava was obligated to ensure that only dedicated Kathak artists are awarded this prestigious fellowship, as there are very less number of seats in this particular fellowship. The eligibility criteria also clearly stated that only those candidates who are particularly and exclusively Kathak performers can take part or can apply for this particular fellowship. However, the ballet video depicting Ms. Kaveri's involvement in the non-Kathak dance form raised legitimate concerns regarding her eligibility and commitment to Kathak. It is further submitted that Prabha did not act arbitrarily, but instead relied on the expert opinions to evaluate the authenticity and implications of the curriculum. The Supreme Court in the case of Center for Public Interest Litigation versus Union of India emphasized that the integrity of selection process should be maintained at all costs if the institutional credibility is at stake. Prava's decision in this particular case is therefore in furtherance of this principle of maintaining the credibility of the selection process, of Prava as an organization, and of the government as well. Furthermore, Ms. Kaveri's claim that the video was a deep fake remains unsubstantiated. Prava, acting in good faith, assessed the matter through an expert scrutiny rather than just outrightly dismissing the application of Ms. Kaveri. The Supreme Court in the case of Union of India versus Rakesh Kumar held that any evidence that reasonably questions the claims of the candidate must be thoroughly examined. In the present case, the video raised legitimate concerns that whether Ms. Kaveri and the applicant, who is the applicant, is actually exclusively involved in Kathak or not. The council submits that the scrutiny of the petitioner's social media posts aim to uphold the procedural integrity of the selection process. Given the limited number of fellowships, it was essential to ensure that only truly meritorious applicants are given a chance in this particular selection. It is humbly submitted that Section 3C of the Cyber Individual Data Protection Act explicitly states that the Act does not apply to personal data made publicly available by the data. The included illustration clarifies that if an individual voluntarily shares the personal data on social media, the Act's data do not extend to such data. Applying this principle, Ms. Kaveri had a Facebook account where she publicly posted the school activities and on her performances. By voluntarily making them publicly available, she placed the data outside the Act's scope. But I'd like to bring to your Lordship's attention that though the section says that the data that is voluntarily posted by the data principal does not fall within the purview of this Act, it does not mean that the data principal in this actual particular case cannot file a case to protect his or her data. There are certain articles like Article 21, certain sections of several acts which will be further dealt by the council in the further issue. Additionally, deepfake or manipulated videos could have resulted from third-party misuse of the publicly available data, and Prava cannot be held liable for the content it did not take or disseminate. Further, it is humbly submitted that Prava's decision to reject Ms. Kaveri's candidature was based on thorough expert review and was not arbitrary. The Supreme Court in the case of Basaiva versus Dr. H.L. Ramesh held that it is a settled legal position that the courts have to show deference and consideration to the recommendation of expert committees. In the present case, Prava's panel of 3 experts confirmed that Ms. Kaveri was involved in another dance form, providing a valid objective basis for her rejection. Additionally, in the case of Bihar School Examination Board versus Subhash Kumar, the court reaffirmed that decisions based on expert assessments must be presumed valid
reasonable and justified. It is humbly submitted that the expert scrutiny conducted by this body ensured transparency and objectivity, establishing that the rejection was completely fair and not arbitrary. In the case of Madhya Pradesh versus Ramesh Chandra, the Supreme Court held that expert evaluations within the defined frameworks must be accorded deference, and claims of arbitrariness cannot override the established procedure or processes. The rejection in this particular case followed the verification and was neither arbitrary nor unfounded. In the case of K. Manjusri versus State of Andhra Pradesh, a stark difference between eligibility and suitability was seen. The case aptly stated the first step as eligibility, which includes all the candidates or all the people who meet all the requirements of the particular rule and can be included in the merit list. Whereas suitability is where the most deserving candidates are required to be recruited. In the present case, the fellowships demand not only artistic excellence but also impeccable public conduct and cultural sensitivity to uphold its prestige. Eligibility alone is not enough. Suitability is also equally important, and here Ms. Kapili lacks both, thereby making her unfit to be a part of the fellowship, and thereby her rejection is very much justified. Furthermore, the petitioner councils have also submitted in para 5, page 17 of their written submissions as well as in their oral submissions that there has been an insignificant error on the behalf or on the part of the candidate. This evidently defies the suitability criteria, thereby making the candidate misfit for this particular position. The petitioners has alleged that the video was a deep fake, but has failed to prove. The only claim that is supporting that the video was a deep fake is Ms. Kaveri's straight statement, who believed that this particular video can be manipulated. The High Court also dismissed the particular petition as it could not be conclusively established that the video that was deep fake was the same video that was uploaded on Prabhas server. It is further established in the case of Talbat Abbas versus Dr. B.S. where the Supreme Court ruled that the selection committee decisions can only be interfered with on limited grounds, such as illegality, procedural irregularities, or proven malpractice. Here, the expert body referred to by Prabha functions analogously to such selection. All alleged irregularities have been justified and no proven malpractice have been shown. Prabha's reliance on the parallel video as evidence of lack of exclusivity aligns with these principles, ensuring procedural integrity was maintained throughout the process. In the case of Union of India versus S. Vinod Kumar, it was held that the candidates who willingly participate in the selection process under a known procedure cannot meet the challenge. Prabha here is committed to preserving the classical dance form and upholds a strict eligibility criteria to maintain the authenticity of Kathak and other cultural dance forms. The exclusive requirement ensures that only dedicated Kathak performers represent the art form. Prabha's objectives making it just and not arbitrary. It is humbly said that Ms. Kaveri's social media conduct was relevant to her suitability for the position. In her debate video, she made remarks that
seen or evaluated by experts. You are not elaborating anything regarding those experts.
Your Lordship, the
And
proposition.
would they be, this was it, say your argument. Supposing your experts, that's what you have indicated, your experts evaluated, they said that yes, certainly it does not appear to be manipulated or the same which she had concluded. Would she have any say in that matter? And look here, why don't you have it evaluated from, say, experts from the IIT or for that matter, or some other cyber experts or something?
Your Lordship, the Council will bring your attention to page 2, para 8 of the Moot proposition, which says that the evaluation process is very transparent and a special board of examiners is constituted as an experts for the same. It involves scrutiny of application, checking if all the criteria fulfilled and assessing the video submitted by the candidate. As per the process, the name of the candidates is shared with various experts. The proposition does not really explain what various experts mean, but it can easily presume that if digital data is being held and being taken care of in this particular case, there must have been technological experts as well that have been assessing the data.
I was coming to that. Page 4 of your write-up, actually. This Moot proposition. Starts with that she had objected to, once you found it, that it was certainly in order, the video which was shown her carrying out that fusion formative value and she requests for reconsideration, which you reject.
Yes, Your Lordship, in present case, if the Prabha would have reconsidered this, Your Lordship, the Council would like to express that they have not refused the application of Ms. Kaveri was considered. There was and specific reasons of the refusals have also been stated, which means that they have taken into care what all the grievances of Ms. Kaveri was. And it has also been stated on para 13, continuing para, which says that they also refused to accept the deepfake video case as no obscenity is seen in the videos and as such no false information is also given through this video.
So what we have, supposing there is no obscenity matter, it has been manipulated. Would not that fall within the ambit of being deepfake or manipulated?
Your Lordship, there is no such evident fact that in the whole proposition it states that the video is being manipulated and the onus to prove that the video is manipulated is on the petitioners and the petitioners have declared assumptions that the video is manipulated and Ms. Kaveri is also made believe that she is wearing the same costume that she has submitted, whereas the High Court dismissed the petition by saying that they could not establish that it was the same video Ms. Kaveri submitted on Prabha's side. So how, in this particular case, Prabha cannot be held liable for any such manipulation or deepfake. Whereas, considering absolutely the question, if Prabha was to give any chance of hearing to Ms. Kaveri, so that would have been unfair with all other candidates as well.
What is your opinion about the sentence written in the Moot proposition at page 3 in para, last two lines of para 3. The police investigated an intern, found that although there was data breach from server of Prava, but no malicious contents and misinformation about Kaveri was found.
Yes, Lordship. Your Lordship, in this particular case, the nature of breach of data is not defined. The police would have examined the whole case and they found that there was no malicious or misleading content found about Ms. Kaveri. Whereas Prava is an organization under the ministry which takes care of many types of data.
Does it not mean that there was no deepfake in the video concern?
Yes, Your Lordship.
It should be your argument.
Your Lordship, legitimate concern over whether she was suitable for such role or not. The Supreme Court in the case of Shahu versus Sheikh Imtiaz Ahmed held that an organization has a right to prescribe qualifications and assess whether a candidate aligns with the functional needs of the position. Prabha's evaluation of cultural sensitivity was directly relevant to this particular selection process. Page 18 of the memorial. Your Lordship, the Council would like to please draw your attention to page 18 of the memorial, where the case of Shares and Maharaj is present. Shares and Maharaj case talked about the reasonable restrictions present under 19.2 of Article 19.2 of the Constitution of Tripura, which also has a clause that friendly relations are not acceptable. The remarks made by Ms. Kaveri were against the cultural ethos of the Sagi Maharaj, which could hamper the friendly relations in future if Ms. Kaveri was made the brand ambassador in this particular case. It is humbly submitted that Ms. Kaveri's remarks, as noted in the proposition, reflected insensitivity towards the neighboring community's cultural ethos. Given the fellowship's aim of fostering cultural unity and promoting Kathak's heritage, such statements are relevant. In the case of Bharatiya Janata Party versus State, the court held that individuals in public-facing roles, especially those representing cultural traditions, must uphold values to respect and sensitivity towards all communities, justifying culturally insensitive attitudes which would question the nation's sincerity in protecting its cultural rights and respecting the cultural integrity in other communities. The Supreme Court in the case of Union of India versus R.S. Sani also held that the vast conduct that reflects a disregard of societal norms can be considered when evaluating present suitability. Prabha's decision to factor in her public statements was therefore justified and not arbitrary. It is humbly submitted that Prabha has maintained fairness and transparency in this particular selection process. In the case of Jyoti K.K. versus Kerala Public Service Commission, the Supreme Court held that it is for the organization to determine the relevancy and suitability of the qualifications for a post. In this case, the petitioner's rejection was based on due consideration of these factors, which are crucial for appointing an ambassador and granting a highly prominent fellowship. Further, in the case of State of Chhatrapati versus Ravi Shankar Prasad, the Supreme Court held that organizations are presumed to act in good faith, and the burden lies on the claimant to prove procedural lapses. Here, the petitioner must present cogent evidence of irregularity. Allowing reconsideration based only on the allegations can lead to numerous petitions from other rejected candidates as well. Prabha's reliance, Your Lordship, the Council seeks a position of 2 minutes. Much of that, Your Lordship. Prabha's reliance on expert evaluation and transparent selection process ensures its decisions was neither arbitrary nor capricious. It is further humbly submitted that all claims made by Ms. Kaveri are based on mere presumptions, lacking any substantive evidence to support her allegations. She has failed to prove or to provide inconclusive proof that the medium in question was the accused, nor has she established any direct link between the data breach from Prabha's server and the deepfake. The police investigation itself found no evidence of Prabha's involvement in any investigation, in any breach, further weakening Ms. Kaveri's case. Additionally, her allegations appear to stem from personal disappointment over not being selected for the fellowship rather than from any genuine procedural irregularity. Mere dissatisfaction with a certain outcome of a competitive selection process does not warrant judicial interference, especially in the absence of tangible proof of injustice or bias. Therefore, the rejection of Ms. Kaveri's candidature was legally justified, procedurally fair, and aligned with the objectives of the fellowship. The Council.
1 minute. Her speech was related to a debate. on the development of economy through culture.
Yeah.
At that time she was also minor. Then how it is against the neighboring countries community?
Your Lordship, here those particular speech indicated the ideas of Miss Kali. But howsoever, for the sake of Your Lordship, the council needs extension to answer this particular question. Your Lordship, howsoever, if for the sake of the arguments, we consider that at that particular point of time, Miss Kaveri was not mature enough to make like decisions, or she was under an obligation. So after that video, posting of that video, there was a gap of 12 years, and when Ms. Kaveri was applying for this application, she must have an idea that what is the need for this application. So she would have deleted or removed that video, knowing that this could be a stringent thing to later apply in this particular application process. Whereas on page 3 of the Moot proposition, para 11 says that Ms. Kaveri was also under tremendous shock. After many years, she again opened her save book account, but she did not see anything odd except the old post from the school days. Even after 12 years, when she was 29 years old, she did not see anything odd in those old posts, which included the debate. It means that her thoughts were still the same about cultural authorities and the cultural authorities of the Sandhya community, which can be a problem and can hamper the nation's relations. The council is done with the submissions of issue 1 and seeks permission to call on the council to deal with the issues. The council seeks permission to use the rights. The council seeks permission to refer the bench collectively as your lordship. Warm greetings to the court. The council seeks permission to proceed with issue 2. Your lordship. Issue 2 for the present case is that is Prabha liable to pay compensation to Ms. Kaveri for the legal injury caused to her due to the negligence of the data breach from Prabha's server. It is humbly submitted before the Honorable Court that Prabha is not liable to pay compensation to Ms. Kaveri for the legal injury caused to her, since Prabha has taken the reasonable measures and security safeguards to protect the data as a responsible organization, and there has been no conclusive evidence that has established that the data breach led to any reputational harm to Ms. Kaveri. Therefore, it is contended that Prabha acted in good faith and followed the due process, and thus should not be held liable to pay the damages. The council shall be dealing with this issue in a twofold manner, that is, that the data breach from Prabha's server does not constitute negligence and breach of duty of care on the part of Prabha, that Prabha is not liable for paying compensation to Ms. Kaveri for the legal injury caused to her by the alleged negligence. To begin with the first sub-issue, the council humbly submits that Prabha has duly complied with the reasonable security practices and safeguards as a responsible organization that works under the government of Tirupala, satisfying the criteria mentioned under Section 8(5) of the Cyber Individual Data Protection Act, the DPDP Act, which mandates that a data fiduciary must follow the reasonable means to protect the data, which implies that there should be no willful negligence on the part of the organization. In this particular case, not only did Prabha comply with the safety measures, not only did Prabha took the reasonable safety measures, but Prabha also ensured that there was no willful negligence on the part of the organization, thereby establishing the criteria mentioned under this section. This can be proven by the council would like to draw the attention of the court towards the council seeks a moment of indulgence, Your Lordship. The council would like to draw the attention of the court towards page 4, paragraph 15 of the Moot proposition, wherein it is clearly complied to, and there was no willful negligence on the part of the organization. It is further humbly submitted that Ms. Kaveri had already an account on the social media platforms wherein she continuously posted her performances. These very performances helped her to become famous in a very short time, thereby proving that the videos were already in the public domain. Here, and anyone, since these videos were already in the public domain on the internet platforms, anyone could have easily accessed them. Now, only one video was uploaded on the server of Tara. For the sake of arguments, if we also agree that the data breach was regarding Ms. Kaveri, here only one video was uploaded on the server of Tara. What about the other videos that are also surfacing on the internet? Because the videos were not only uploaded on the official accounts of Ms. Kaveri, but the videos were also uploaded by the organizations for whom Ms. Kaveri performed. The Council would like to draw the attention of the Honorable Court towards page 1, para 2 of the Moot proposition. In the last line it says, her dance performances were available on various social media sites as organizers of the event used to post the recordings on their official pages, which means that there was enough access available to the data of Ms. Kaveri, which means that Prabha is not the only organization which had the data of Ms. Kaveri. And herein, it has also been proven that the data breach did not have any misinformation or malicious content about Ms. Kaveri. It is further humbly submitted that Prabha should not be held liable for the videos that are already available in the public domain, and which is a mere speculation that those videos led to the deepfake creation. It is further humbly submitted that the creation and dissemination.
But as per Kaveri, she found that her hand movement got converted to ballet movement. Actually, she was not performing ballet. She was performing only Kathak. She found that her hand movement got converted to ballet dance movement. The whole episode was beyond Kaveri's understanding, as she never performed ballet and actually been involved in Kathak performance.
The Lordship, in the present case, as my co-counsel has already established, that many videos were surfacing, and Prabha is an organization which is duty bound to select the best suitable candidate for the post of the ambassador. We have to make sure that we are selecting a candidate whose background, whose social background is clean, and we are duly compliant with the eligibility criteria that has been mentioned. The eligibility criteria that is mentioned in the Moot proposition on page 2, para 17, is that the candidate must exclusively be involved in Kathak performance. And as it has been already mentioned, that there was stringent scrutiny on the part of the organization regarding the dance videos that were uploaded. Now here, when Prabha got to know that Ms. Kaveri is involved in other dance forms, her application was therefore rejected. And if Ms. Kaveri thinks that the video is deepfake video, she can establish that before the Honorable Court, and the organization will not have any problem with that. However, in the present issue, the major allegation of the petitioner is that the creation of the deepfake video, the dissemination of the deepfake video, was as a result of the negligence of the organization, that is Prabha, which is completely false. Because of which the council is contending before the Honorable. It is further humbly submitted that the creation and dissemination of the deepfake video was a novus actus intervenes. That means it was a third-party action, as there is no causation chain that has been established between the data breach and the creation of the deepfake video. This intervening act was not reasonably foreseeable by Prabha, and which this particular intervening act, which is said to have a significant role to play in the reputation harm which has been alleged to have been suffered by Ms. Kaveri. This was not reasonably foreseeable by Prabha that it was having the data and there will be a data breach. Moreover, the data breach, the nature of the data breach is not very clear. So for the sake of arguments, even if we agree that there was a data breach what Ms. Kaveri thinks, Prabha could not have foreseen that the data breach would lead to the creation of the deepfake videos, particularly when so many videos are already resurfacing on the social media platforms. Because of the videos that were already available in the social media platform as a result of the videos that were uploaded on your account, as well as
organizations for which she had performed. It is further therefore Prabha cannot be held liable for the third party action in the present case. The fact it is further humbly submitted that the data breach was not due to the gross negligence but because it was an unforeseeable cyber incident. The Council would like to draw the attention of the court towards page 25 of the written submission on behalf of the respondents. It is para 2.1.6. It is simply submitted that in the case of Jacob Matthew versus State of Punjab and Municipal Corporation of Greater Bombay versus Lakshman Iyer, the Supreme Court held that negligence becomes actionable on account of injury resulting from the act or omission amounting to negligence attributable to the person sued. So the negligence which is resulting to the harm that has been alleged should be attributable to the person sued. In this particular case, the harm that Ms. Kaveri is claiming to have suffered, that is the reputational harm, cannot be attributed to the organization, that is Prabha, because the data breach was not about the information about Ms. Kaveri as has been already proven by the police investigation report. According to the principle of forcibility in negligence law, in order to establish negligence to attach to the parties must have established a relationship recognized by law as the foundation of a duty to care. In the absence of a duty to prevent an injury, possibility that an injury is an insufficient basis on which to rest liability. In the present case, Prabha was not obliged to prevent any harm to Ms. Kaveri resulting from the creation of a deepfake video using publicly available footage on her social media accounts.
There is just one. Okay, evidently there was a data breach. The report says there was no malicious content and misinformation about Kaveri was found. Malicious as per the police. Malicious could be said, supposing the video could have been changed to phone or anyone. Could be malicious to that extent. But here was a case in which the video in which he was performing a particular Indian dance that was changed into a ballet one. So it would not be per se malicious. It would not be per se malicious. It would not be any misinformation. It would be change of the dance form, say for entertainment purpose itself. So look here, an Indian dancer can also perform whatever ballet, whichever dance form is ballet. So it would not come in the ambit of being either malicious content or any misinformation. That was also the purpose of entertainment. Now, admittedly data breach, admittedly, or for that matter, as per the police, it is neither malicious nor misinformation. But changing of the dance form has resulted into she being rejected as being a brand ambassador. What do you have to say with regard to that? In case you prepared to that.
Your Lordship, in the present case, the rejection was not only on the basis of her dance videos that were converted, which is alleged to have been deepfaked by the petitioner, which is not clearly established. It was also on the basis of the video that she had uploaded when she was 17 years old.
But at that time she was a minor. So how far would a major be liable for an action that might have been submitted by him or her at the time of being a minor?
Your Lordship, in the present case, the reason why the organization has considered that video is because the organization has to appoint an individual who is representing the cultures of different endeavors, who is representing the cultures of different, who is representing the culture of the country, as well as who has to respect the culture of the other friendly states as well. In the present case, Ms. Kaveri uploaded that video when she was 17 years old. For the sake of arguments, we agree that okay, at that particular point in time she was a minor, and she did not have an understanding of the consequences of what she said. However, Your Lordship, the Council would like to draw the attention of the court towards 3 of the Moot proposition, wherein it is clearly said that after many years she opened her Facebook account. But she did not see anything odd on that except her old post from the school days, including a post where she is debating on that topic in which she criticized the approach of various communities living in the various countries like Saudi towards dance. So here in the present case, it means that the views of Ms. Kaveri, she did not find anything odd, which means that she still agrees with what she said at that particular point of time. So it was not only under the obligation of the debate competition, but it was actually her original views. And to appoint such a person, to take into account the application of such a person who is culturally insensitive towards a community, my lordship, which is highly appreciated and taking interest in learning the dance forms present in the country of Tirupura. The council would like to draw the attention of the...
Slightly building on that. I told the debate in which we are entered as a minor. Now, a debate, one topic is given. Somebody argues for the motion, somebody argues against the motion. Unfortunately, supposing culture of a particular country was working for, obviously, the person arguing in favor of the motion would be externally and glorifying that particular culture. And the other person who is arguing against the motion, he has got no option but to replicate that. What do you have to say regarding that? Because it was a debate, a school debate, perhaps 70 years, or a school debate.
Your Lordship, the council is understanding all the points raised by your Lordships that it was a school debate paper, she was under an obligation. The point that is contended by the council here is that she very much knew when she was applying for the post of the ambassador that this particular video will have a consequence. And under section 12 of the Cyber Data and Individual Protection Act, it provides the right to be forgotten, which means that she had the opportunity to get the videos deleted from the account. If she knew,
When did the act come?
Your Lordships in 2023.
And she was 17, is applied that would this have retrospective operation?
Your Lordships, she had opened her account after her application was rejected. So, when she had opened her account, by that time the act was already inactive. So then she had this remedy available with her. Then she could have got the videos removed. And even in that case, that would have shown an effort from the side of the candidate that they are trying their best to clean the social background, which is of the ultimate importance in the present case. Because as the council has already pointed out, that the Sakipura community was taking interest in learning the dance forms here. So we cannot destroy our friendly relations with the other foreign states, which is also a reasonable restriction on the freedom of speech and expression.
Is it right to speak about the Act 23?
Section 12. Your Lordship. The right to be forgotten is also recognized by the GDPR regulations of the European Union. So even that provided protection. Moreover, and it is a developing concept, however, the remedy was still available. The Lordships, in the present case, it is further only submitted that the data breach was not due to it was an unforeseeable cyber incident. And here, Prabha had no duty to care in the present case to prevent the damage that has been suffered by Ms. Kaveri, the alleged damage that has been suffered by Ms. Kaveri as a result of the creation of the deepfake videos. Cybersecurity breaches can occur despite implementing reasonable and industry safeguards because no system can guarantee absolute protection against ensuring cyber risks. And in the present case, even if we consider the data breach, since the nature of the data breach is not established, this proves that the data breach and the data breach, no malicious content about Ms. Kaveri was found, meaning thereby that there was no information about Ms. Kaveri that was leaked. Moreover, Your Lordship, when we are talking about the server of an organization, the organization has a single server wherein the data of all the other candidates must have also been saved. So if we are implying that the data breach occurred and the data of Ms. Kaveri was leaked, then we also have to understand that the particular server must also be having the data of the other candidate. However, these discrepancies in the data breach is only being raised by the side of the petitioner, that is Ms. Kaveri, and not any other candidates. There were 103 candidates that applied, out of which 3 candidates were selected. 100 other candidates, including Ms. Kaveri, were not selected. However, they had not complained of any such discrepancy, meaning thereby that the database that happened was not related to the candidates who had applied for the fellowship program. Your Lordships,
Question I have. Kaveri's data system as per this DPDP Act. Okay. And I think the Prava is the data fiduciary.
yes, Lordship.
Okay. Whether Prava has obtained any consent of Kaveri under section 6 regarding the data which Prava has processed.
Your Lordships, in the present case, when we are talking about processing of the data, processing means using the information to gain something. In this particular case,
You are not getting something from this data.
we are only referring to the data.
Assessing her status, what she has got about a country, how she is performing dance. You are assessing her quality and character with the help of this data. So why did you not take consent?
Your Lordship, in the present case, this was the eligibility criteria that has been mentioned in the Moot proposition. It says that the applicant must be exclusively a dance performer, which means, and this word exclusivity means that it was in the hands of the organization to decide and to ensure that the particular candidate that is applying for the fellowship is exclusively indeed a Kathak dance performer. Moreover, Your Lordship, my co-counsel already pointed out section 3C of the DPDP Act, which says that the data that is already publicly available, that does not avail the protections of this Act. So, in this particular case, as the council has already established that the already publicly available data was accessed. Here, meaning thereby that the protections of this Act will not apply to those particular videos that were uploaded voluntarily by Ms. Kaveri on her social media accounts. Moreover, this is justified by the eligibility criteria that has been mentioned by the organization. If your Lordship is satisfied, you can answer the council would like to make much obliged.
You are satisfied or not giving reflecting judgment, not on bias.
Your Lordship. Your Lordship, in the present case, since the council would like to draw the attention of the court towards page 28 of the memorial on behalf of the respondents. Your Lordship, in the present case, the case of unforeseeable limited versus Beckman, Coulter International, it was held that the court held that the entities are not liable for breaches caused by unforeseeable cyber attacks. So in the present case, since the attacks were unforeseeable, the organization was not liable. Moreover, Your Lordship, moving to the second sub-issue of this particular issue, Prava is not liable to take compensation because the reasonable safety measures were already undertaken by the organization. Meaning that there was no willful negligence, there was no data breach which led to the creation and dissemination of the deepfake video, which ultimately led to the reputation harm, and therefore the organization is not liable to pay compensation to Ms. Kaveri for the alleged harm that has been caused by her. Moreover, there has been no substantial evidence to establish a direct link between the alleged breach and the deepfake video that has been created. If the Lordship is satisfied with issue 2, the council will seek permission to proceed with issue 3. Much obliged, Lordship. Issue 3 for the present case is whether there is a need to issue guidelines to regulate artificial intelligence in general and deepfakes in particular, by the Supreme Court. Your Lordship, it is most humbly submitted that even though the concerns regarding the misuse of the deepfake technology are valid, it is humbly submitted before the Honorable Court to consider the fact that there are already adequate legislations available in the country of Tirupala to deal with the issues of deepfake. To begin with the legislations, the first legislation is the very example in which the petitioners have approached this court, that is the Cyber Individual Data Protection Act, the DPDP Act, in which they have approached the court. This particular section deals not only with the publicly available data, but it also deals with the responsibilities of the data fiduciary and how the data fiduciary will deal with the database. It also provides for the establishment of the data protection board, which will lead to the inquiries and investigations that has to be made regarding the deepfakes. Moving ahead, there is also an act, the Information Technology Act, that is prevalent in the country. In this particular act, there is section 66E, 66D, cheating by personation. There is 66E, which deals with the violation of privacy. There is 66C that is prevalent in this particular section. All of these sections in the IT Act prove that the IT Act is also sufficient in dealing with the issues of deepfake. Moreover, Your Lordship, in the BNS, there is also a provision of defamation that is mentioned under section 356 and 356 clause 1 and 356 clause 2. Moreover, Your Lordship, as far as the copyright concerns might also be coming before the Honorable Court in cases of deepfake. The Copyright Act of 1957, under its section 51, deals with the copyright claim. Your Lordships, this proves, and moreover, the most important right that is available with the citizen is the right to privacy that has been upheld by the case with the Swami case. That if there is a violation of privacy because of the case of the citizens can approach the court under the relevant sections of that is Article 31 of the Constitution. The Council further humbly submits that the judiciary must trust the wisdom of the legislature to come up with such laws that are sufficient in dealing with these evolving technology that pose danger to the rights of the citizens. The legislature has done so in the past. The example being the IT rules depending on the need and development, the IT intermediary guidelines and the digital media ethics code, rules 2021, and before that we had the IT reasonable security practices and procedures in sensitive personal data or information rules 2011, which means that there was an IT Act in 2000 to enable it and to further increase its ambit, to further enhance its ambit. The legislature also came up with certain rules. So it is a request on the part of the council to trust the wisdom of the legislature in coming up with the laws. Moreover, Your Lordship, Tirupala, being a democratic country, upholds the principle of separation of power. The legislature, making a legislation to deal with a particular issue is the domain of the legislature, and the particular work of the judiciary is to interpret the already existing laws. In the present case, the council would request Your Lordships to this particular separation of power is also guaranteed under Article 121 and 211 of the Constitution, Article 122 and 212 of the Constitution, Article 361 of the Constitution, and Article 50 of the Constitution, which means that the work of coming up with the legislation, the Council seeks extension of time. Much obliged, Your Lordship. In the present scenario, the work of coming up with the legislation should be left with the legislature respecting abiding by the principle of doctrine of separation of power. Mostly, moving ahead, Your Lordship, the judiciary here lacks the technical expertise for the purpose of making the particular legislation. The legislature, when while making laws on topics which are evolving, which are new, they set up committees which come up with these legislations. In the present case as well, the work of the legislature should be, the work of coming up with the legislation should be left with the legislature so that they can set up the committee and they can come up with such laws if needed. Moreover, Your Lordship, in the present case, if the Supreme Court issues guidelines and there are already the existing laws have already been pointed out by the Council, in the present case, Your Lordship, that would lead to chaos and confusion because there will be the guidelines that will be applicable and there will be the already existing laws that are prevalent in the country, which will make it difficult for the citizens to approach the court under the right provisions. If Your Lordship is satisfied with issue 3, the Council will seek permission to proceed with the prayer.
One question I have to ask. There is a provision of data protection board. Why there is an alternate remedy also for the legislation? What about your opinion? What is your opinion?
Your Lordship, the opinion that Council would have is that Ms. Kaveri should have approached the data protection board, however she decided to approach the High Court. That is something that can be established by the petitioners themselves. The only intention of the Council was to point out that this particular arrangement is prevalent under the forfeited, but the provision of compensation can also be brought about by the suit of defamation that was already filed by Ms. Kaveri. So in the present case, the council basically submits that in the present case there are adequate laws. However, respecting the provision of the doctrine of separation of powers, the judiciary should take into consideration that the laws are adequate, that the legislature is capable of enough of becoming the laws. However, if it pleases the court, they may pass the legislation. The council will seek permission to proceed with the prayer. Much obliged. Therefore, it is humbly prayed in the light of the issues raised, arguments advanced, and authorities cited, it is most humbly and respectfully prayed before this honorable court that it may be pleased to hold adjudge and declare that the rejection of Ms. Kaveri's candidature was justified and valid, that Prabha is not liable to pay compensation to Ms. Kaveri, and there is no direct link that has been established between the data breach and the alleged harm that has been suffered by Ms. Kaveri, to issue guidelines to regulate AI in general and deepfake in particular if the court pleases, and or pass any other relief or direction that the court deems best, deems fit best in the interest of justice, fairness, and good conscience. For this act of kindness, the respondent shall be duty bound forever paid, all of which have been respectfully submitted. Your Lordship, the council is done with the argument. It was a pleasure having you with us. Much obliged.
Permission to approach the dais for rebuttals. At the outset, I request this court that it pay due attention to me, because every argument that I am going to make is going to destroy the case completely in its totality. Please take due note of every argument that I make, Lordship. Not at all, my Lordship. Actually, sometimes some mentioning will be emphasizing. Sorry, my Lordship. 14 to 22 of their memorial, they have nowhere argued on the test of arbitrariness. In matters like this, state has to satisfy that the decision taken fulfills the test of arbitrariness. They have not applied or relied on any cases whatsoever to fulfill this. I submit this case law, which says that state is modern employer and governed by 14 and 16. They applied the test which were comfortable and suitable to them. Now, please refer to page number 14 of their argument. They say they have relied on a case, Center for Public Interest Litigation and Other Laws of Union of India, in which they agree that integrity of the selection process must be preserved. Now, I submit for your perusal Renu Sharma's case, in which this was my fourth prong of submission. That another part they have skipped out, prejudicial impact of a decision on the candidate. That is not been balanced again. And I already submitted that the sanctity already stands nullified in question. Now, Lordship, it is not a belief that the video is a deep fake. It is a statement in prong. Lordship referred to that para. If Lordship remembers, para 13. Now, please read the last para of the same, if I may have your attention there. Para 13 of the Moot prong. Thus, someone made a deepfake out of the video that Ms. Kaveri had shot for her fellowship. Lordship, please note that. It's a conclusion. Thus, para 13. Lordship, Moot prong, para 13. Just 1, 2, 3, 4, 5, 6, 7. To the page, Lordship. Actually, is that Moot prong not containing any paragraph number also that contain any page? I understand, Lordship. Third page, last line, Lordship. Thus, someone made a deep fake out of the video of Ms. Kaveri. It's a conclusion. The prop is balanced. It is saying that it is a deep fake. As such, we need not establish that it is a deep fake. So that argument holds no water. That we are duty bound to establish that the video was a deep fake. Please take note of that, because their argument stood on those legs, Lordship. Now, Lordship, res ipsa loquitur is rightly invoked in my case. Lordship, there is a breach. and they have not reported the breach. As per SERPIN guidelines, Computer Emergency Response Team, India, the highest, we can say, digital security force of India. It clearly says if there is a breach, it has to be reported within 6 hours. Did they report it? Why did they not report it? These things enables me to invoke the doctrine of res ipsa loquitur and shift the burden on them. As such, it is they that have to satisfy this code. Burden stands, onus stands shifted to them. They have to satisfy with this code. That why did they not report or why was the breach? So the burden is not on us, Lordship. And so far as the argument of causal link goes, they conveniently argued causal link is absent. What is the test on which you say whether the causal link is present or not? I already took my Lordship to those lines. Para 4, if you remember, Lordship. That video is similar to the video uploaded on the server. And there is a breach. Sufficient preponderance of probabilities in my favor to argue that causal link exists. And they went to the extent to argue that there is no damage. My Lordship, there is damage, that fellowship has not been given to her. Biggest damage. And second damage is right to livelihood, which was recognized as a fundamental right by this Honorable Court in Olga Delhi. She is a dancer. Her lifestyle revolves around earning her livelihood by dances. Now this case's publicity, coupled with the reputation lost she has underwent, all these employment prospects are affected. Now one argument which kept running was police says there is a breach, but no misinformation was leaked. Can the police conclusively ever say that, Lordship? The attacker only knows what method he adopted in attacking. What if he didn't adopt the stealing method but the copying method? He copied the data. Merely copied the data, all data remains there. So only the attacker knows what all data he has stolen and which data he wants to pertinently use and defame which candidate. He may have had nothing against all the other 3 candidates, 103 candidates. He had something against her. So this has to be taken note. This is a point I emphasize upon because this argument, no misinformation, the police can never say that. Only the authority, only the attacker knows, Lordship. Now, Lordship, she kept using the word willful negligence. Now, or logically speaking, if something is willful, negligence does away with willfulness. That is why it is negligence. How can, if a negligence is willful, it is no longer negligence, Lordship. What is willful negligence? There is no terminology as such. And she relied upon one case, Jacob method. Jacob method dealt with medical negligence and not negligence as such. Now, Lordship, she also established the 3 duties: duty, breach, and damage. There is a duty to care. I took my Lordship through section 8 of the DPDP Act, 8 clause 7. And I also emphasized in my arguments that I am not merely claiming the breach on the basis of the breach and the damage, but also on the basis of breach of the storage limitation principle. What was the data doing there once the data's purpose was served? They are negligent here. Why didn't they delete it? On those lines, no submission whatsoever was made by the respondents.
Who did not delete it?
Lordship?
Who did not delete it? Who is responsible for its deletion?
Deletion, the data fiduciary, Lordship, in our case, Prava. Section 8 is the obligations of data fiduciary.
Why did you delete before examining the data?
Lordship?
Why did you delete before examining the data?
Lordship, after examining the data, it should have been deleted. It outlasted its purpose and stayed on the server. That is my argument, Lordship. And that is why the breach of storage limitation is involved. I had taken Lords through 8 clause 7, if my Lords remember rightly.
Section
8 clause 7.
A data fiduciary shall, unless retention is necessary for compliance with any law.
Clause A, 8 clause 7A, Lordship, yes.
Erase personal data upon the data principal withdrawing her consent or as soon as it is reasonable to assume that the specified purpose is no longer.
Yes, Lordship. Precisely.
Whichever is earlier.
Yes, Lordship. Now, Lordship.
Was the consent withdrawn? Was the consent withdrawn?
Consent, Lordship, consent may be given, but I had given consent to the tune of examining my video for just.
You talk about the erasure or the data fiduciary to erase it.
Yes.
So this is
Consent is not necessary, Lordship. Or it is supplemented by the word or. 8 clause 7, Lordship. 8 plus 7, yes, Lordship. Thank you, Lordship. Yes, Lordship. 8 clause 7, if I may be allowed to read the same. 8 clause 7, subclause 8. Approach the data fiduciary for performance of the specified.
No, subsection 7.
Subsection.
Data fiduciary shall
Yes, Lordship. Yes. Unless retention is necessary for compliance with any law for the time being enforced. Clause A, Lordship. Erase personal data upon data principal withdrawing your consent. Or, Lordship, or as soon as it is reasonable to assume that the specified purpose is no longer served.
From where is the data? Is the data
Sir,
data fiduciary to derive that information?
Lordship, there are two things. One way to erase the data is me giving consent and asking explicitly for the erasure. The other way is for them, it is on their responsibility to delete it as soon as the purpose is served.
What was the purpose?
Purpose was to use that video, the data in question, examine it for the purpose of selecting or rejecting the candidate. That purpose should serve. Still, the data outlasted on the server Lordship.
Why didn't you invoke the right to be forwarded?
We did invoke Lordship.
So why didn't you invoke regarding
The reason is Lordship,
as a debate?
Supreme Court currently is sub judice. If I may quote the case, Karthik Theodore case, is sub judice. The court is still considering whether right to be forgotten is to be propounded as a right. They have implemented it in hurry, but no rules whatsoever has been implemented by far. The Act asks us to presume that it is already in effect, but the rules are not in effect. This brings me to my another rebuttal. Why did we approach the data protection board? They said that we should have approached the data protection board. When there is no board as such, how can you approach possibly Lordship? Lordship, since you asked me few questions, I could not complete my rebuttals. I will complete it and then wind up, Lordship. Much obliged, Lordship. Lordship should note that there has been selective exclusion. There are two accounts. Safe book is an inactive account. This part was never considered by them. It is on this inactive account all deepfake videos are there. We don't know who is using it now. She had deactivated it long back. Now somebody else is using that account. How can she be held liable? This was not looked into. And selectively they ignored all the positive posts she posts on social graph. Is there any deepfake video on social graph? And she also attempted to manipulate that she opened another account when she was major. This account was not Facebook. This account was social graph. From that there has been no leaks, Lordship. So somebody else is using the Facebook account. For that she cannot be liable. This basic thing was not gone into by them. Now if I may refer to their memorial, if certain flaws, please refer to page number 23. She has written the argument that reasonable security practices and procedure of sensitive data rules. Now Lordships will remember, this was made, power to make these rules, parent legislation or provision was the IT Act section 43A. And by virtue of section 44 of the DPDP Act, this section itself stands omitted. As said, there is no point whatsoever, how can this be relied upon in the first place? And Lordship also, please note that they had submitted in page number 29 of their memorial, page number 29, case Uttaswamy case. 43A applies, they have written the argument that we cannot claim compensation under 43A. We are not claiming compensation under any statutory provision because they have closed that door for us. We are claiming it under public government. I relied on Hinabati Bera and all this and advanced my argument. And Lordship, they also refer to a principle that once rejected, estoppel comes into effect. You cannot question the selection process. I submit another case to counter that, Sudananda Kula, in which it was said that there is an exception to that rule of favor, which is if the decision is arbitrary and malefied. I established arbitrariness in my case. As such, that principle stands posted. They can't rely on that principle, Lordship. This will be my rebuttals, Lordship. Much obliged.
Lordships, the council seeks permission to proceed with the answer. Much obliged, Your Lordship. To answer the first question that has been raised by the learned council from on the part of the petitioner is that that we have not dealt with the issue of arbitrariness. The council on behalf of the respondents, the first council established that there was no arbitrariness. Arbitrariness means that there should be reasons given. We have given the reasons that for which we have rejected the candidature of Ms. Kaveri. Meaning that we have not rejected a candidature without any reasons just because we did not want to select her. Moreover, Your Lordship, the petitioners have alleged that there was a prejudicial impact on the selection process. Your Lordship, in the present case, there was no prejudicial impact. It was a requirement of the eligibility criteria and it was a responsibility of Prabha to ensure that the candidate that is selected is the most suitable one, that is exclusively involved in Kathak, and that they are capable of becoming an ambassador who is representing the country in international diaspora. If we select the remarks of an individual who is culturally insensitive, what will be the prestige of the nation in the international diaspora when they become the ambassadors of the nation? That was the concern of the Prabha when they rejected the candidature of Ms. Kaveri. Your Lordship, for the sake of arguments, we have said that there was a deepfake video. For the sake of arguments, Your Lordship, first of all, the council would like to draw your attention towards the page that they had pointed out. It was page number 3, para 12. That is the last para of that page, page number 3 of the Moot proposition. The Moot proposition, Your Lordship. Page number 3, the last para. Your Lordship, the third last line mentioned her friend believed this video would be a deepfake video. Thus, someone made a deepfake out of the video. Here, Your Lordship, the learned council has very conveniently missed this statement, her friend believed, and on the basis of which this conclusion has been given. So, this conclusion is not technical, Your Lordship. This particular conclusion is based on the belief of her friend and how an organization that is working under the ministry that is under the responsibility to select the best suited candidate is supposed to believe claims like these. Moreover, Your Lordship, for the sake of arguments, even if we agree that there was a deepfake video, we agree that there was a mod video that was being surfaced, here, Your Lordship, the council, the petitioners are seeking compensation for this particular reputation harm that had been caused to Ms. Kaveri as a result of the deepfake video that was created. Your Lordship, in the present case, then there is no negligence on the part of Prabha which led to the creation of the deepfake video, where there was no direct link between the data breach and the creation of the deepfake video. How is Prabha liable to pay compensation to them? Here, Prabha has added the council on behalf of the respondent had established that this was a third-party action in this particular case. Therefore, they are not liable to pay compensation. So, which takes me to another question that was posed by the learned council, that we have mentioned section 43A. In the present case, Your Lordship, in the verbal arguments, the council established that 43A has been omitted. And for the sake of arguments, even if we agree that we are asking for compensation, they are not asking for compensation under 43, if that is a consideration that is not to be considered by Prabha, because Prabha has no responsibility to pay compensation to Ms. Kaveri in the present case. Therefore, the section in which they are approaching the court is something that they have to look up. That is not the responsibility of the organization Prabha. Your Lordships, the petitioners have argued that Your Lordships, that there was negligence and duty, breach and damage. The three important essentials of negligence has been established. Your Lordship, in the present case, the counsel for the respondents established that there was no duty of care in this present case because the data breach was not related to the candidates in general. So there was no duty, there was no breach in the present case because it has not been established, and there has been no damage. Consequently, because if there is no duty, if there is no breach, what damage has Prabha done to the petitioner? This particular case seems like an effort that has been made by the petitioner just because of their desperation that they were not selected for the fellowship that they wanted. And this is particularly evident from the price that they have asked, the compensation that they have asked, that is rupees 5 crore. That is the reputation harm that they have quantified in the present case. That was the exact amount that they would have got had they been selected. In the present case, just because they were not selected, they are asking for this particular amount as compensation. Your Lordships, there was no evidence that proved that there was a data that we had that data or not. The petitioner argued that there should have been an erasure of data. Your Lordship, in the present case, the Moot proposition nowhere mentions whether, and there is no mention whatsoever about whether the data of Ms. Kaveri was deleted in the present case or it was still with the organization after the evaluation was made in the present case. So this is just a speculation on part of the petitioner that we have the video with us and we were still having it with us, by which they have pointed out the arbitrariness and malicious intent on our part. In Lordship, they have further argued that the videos are similar to the video that she had uploaded. Your Lordship, this particular statement is mentioned. The council seeks a moment of indulgence, Your Lordship. Your Lordship, it is mentioned in page 3. The last para, the same para where the last line was mentioned about the intake video. The same para, Your Lordship, says the video was similar to the one, not exactly the one, Your Lordship. And we are considering, the petitioners are considering the statement that it was similar over the statement that was made by the High Court itself, wherein they said that it could not be conclusively proven that the video, the deepfake video, was the same video that was uploaded on Prabha's server, Your Lordship. Lastly, Your Lordship, we are not denying that there is damage to Ms. Kaveri. In this present case, what we are denying is that there has been no damage done by the respondents in the present case. If we look at the selection process was fair. It was in accordance with the eligibility criteria and for the ultimate protection of the prestige of the nation in the international times forum. Your Lordship, and if we look at the reputation harm that is being alleged by the petitioner, the reputation harm has already been established by the co-counsel that it is a third-party action. The organization is not liable. Your Lordship, the council will seek permission to seek certain clarifications from the respondents in the present case based on their memorial. Much obliged, Your Lordship. Your Lordship, in the present case, the petitioner's counsel has contended that there was an insignificant error on their part. How Prabha is supposed to reconsider the application of a candidate for the position of the brand ambassador who has made such a significant error? Here it is a significant error, not an insignificant error. That the video was not deleted and that she was performing badly, even though it was a major criteria that she was supposed to be. The council seeks extension of time. Much obliged, Your Lordship. That she was supposed to be exclusively a cut-up dancer. Your Lordship, further the petitioners have contended that there should be no discrimination in employment on the basis of opinion, personal, public, political, as well as violation of Article 16. However, the selection procedure is different from the recruitment and employment. Therefore, their claim remains unsubstantiated on this particular argument. Your Lordship, the petitioners have also contended that in the instant case, the parliamentary approval can be waived, citing the case of Shahu versus Union of India. Completing in this particular case, Your Lordship, this case differs from the present case because there was an obligation on the state to accept to come up with this particular law because of the state law convention. So here, no such convention has been proven, and there is no mention about any such convention and any such obligation in the Moot proposition. Throughout, they have relied on the conventions that India has relied on. Your Lordship, in the present case, we are standing before the case that is prevalent between the Kaveri and the Union of Tirupati. It is not union. Your Lordship, and the Moot proposition mentions no convention that was obligated to convention the Tirupati. Your Lordship, the council is extension of time. Just one second, Your Lordship. Last. Much obliged, Your Lordship. The petitioner contended has added that the deepfake video was created from the alteration of the original data by Prabha, and they have failed to establish or provide how any conclusive proof. Additionally, they have based their claims on claims of compensation on this particular thing. Your Lordship, the petitioners have also contended that the only limited deepfake video they have misstated the facts, Your Lordship. In the present case, the council would like to draw the attention of the court towards page 4 of the Moot proposition, Your Lordship, the first para. They have only pointed out that deepfake case as no obscenity is seen in those videos at this stop. The particular sentence continues and it says, as such, no false information is given through these videos, Your Lordship. This particular statement has been ignored. Moreover, prima facie appears to be Miss Kaveri. The very next line, the video is showing fusion of Kathak and ballet to perform it. Prima facie appears to be Miss Kaveri. So it is not an assumption. It is a conclusion that has been seen. It is prima facie appearing to be Miss Kaveri, Your Lordship. Your Lordship, that is all from the respondent side. Much obliged, Your Lordship. It is an honor answering your question.
scintillating performance by both the teams. And I must admit and also candidly say that the confidence indicated by all the participants, all of you out here, was something that at least we never had when we were in the law school. That was excellent. We never had that confidence. We only developed after having a gear for many months and perhaps years at the bar. It was an excellent performance. One thing that I would say is regarding the overconfidence. You must understand the difference between confidence and overconfidence. Confidence is not it. You are confident about one thing, but you can never be overconfident about it. Overconfidence would result into a weakness. One of the things which I noticed about one of the participants. And overconfidence. Never do that. Never be overconfident about anything. As budding lawyers or going for on the corporate side or for going for the judiciary or any other law office in Afghan, always have one thing in your mind. So I'll be addressing the lawyers first. As a lawyer, try and develop a crux of the issue first. Try to this was a carried on for around 100 hours. Almost 2 hours. Just whoever starts off with the arguments, you start off with the crux of the issues, 2 lines or 3 lines, that draws the attention of the court. And similarly for the other side, you start off because they got the advantage of being the first movers. You have got the disadvantage of following them because they've already put in the impression in the minds of the court. You follow them. So therefore, try and revert them what they might have indicated, not in this particular case, but what the petitioner indicates as a crux of the issue. You have to debunk that to the court. ऐसा नहीं, ये चीज तो बताई नहीं, or for that matter, whatever. I'll just give you one anecdote regarding that. One of my friends, the Consumer Protection Act had taken off. One of my friends came to me. He told me that a rat had got inside his refrigerator. I said, must have cut the line which is there and he bit into the back of it. Back is steel. It's not steel, just have it. Thermocol lagati hai usko. I was surprised by that. And it was a refrigerator. They had launched a new series of refrigerator and much highlighted it. Higher efficiency, higher cooling, low electricity, etc. Then we found that they had a thermal paper stuck at the back and it was thermocol. And machinery was there. Interesting matter. Nobody had ever highlighted that. I and group of lawyers, we took the matter to the Consumer Forum. The Consumer Forum dismissed it. Hilarious observation that had been made by the forum. Is that आपको थोड़ा सचेत होना चाहिए था, जजमेंट हिंदी सचेत होना चाहिए था, क्योंकि उसमें खाली चीज ऐड की जाती है. Rejected. I told that fellow, कुछ है नहीं, कहाँ हमारा? Because at that time there was only one bench available for the state commission also. This was under the old consumption 1986. कुछ नहीं होता है. Lucknow was having only one bench. So throughout the state, जितनी districts सब नहीं आता था, huge backlog etc. कुछ होना नहीं वहाँ. फाइल कर दिए क्या उसमें? बड़ा हुआ. They flown a lawyer from Bombay, designated senior, very reputed one also. Keep seeing in the newspaper so far in Bombay. He flew in from there, was telling us, पूरी हमारा assembly line को charge करी होगी regarding refrigerators. हम लोग सब ऐसी free वाले थे, दोस्त का मुकदमा करते हैं. But in order to sieve out that one particular case, courts 10 बजे अपना बैठे, खींच लाते 4 बजे हो गए. कितना काम कर सकता है एक आदमी जो बेंच दो बैठते हैं, कितना काम कर सकते हैं? Huge around 400-500 cases registered almost in there, every day. So we had to sieve out that particular case and to pick the interest of the court. So we used to start up argument with our government and lost before this one. So we used to start up argument. चूहा फ्रिज खा गया। हाँ, चूहा फ्रिज कैसे खाता था? यही तो है, आइए देखते हैं। So you know that was the एक पर्टिकुलर पिक्यूलियर है, चूहा कैसे फ्रिज खा सकता है, ऐसा वही वही तीन जल्दी मानिए वन दिन हो गया नॉट बी टेकन आउट, उसमें फिर उठते हुए ऐसा आप लोग चूहे, हाँ चूहा का निकल गया था। यूज्ड टू हैव अ डेट फिक्स इन द मैटर, डेट डिलेड बिकॉज़ I used to fly from Mumbai. अब कैसे ये हुआ नहीं, डेट फिक्स होती है अगेन, इट वाज द सेम मोडस ऑपरेंडी दैट यूज्ड टू अडॉप्ट ऑन द सब्सिक्वेंट डेट ऑल्सो। हाँ बताइए, चूहा फ्रिज, हाँ चूहा, दो बजे लेंगे इसको चूहा। So and eventually we won. You know, the court found his and and even that honorable judge, he had won hockey to the court. हाँ मैंने भी जाकर उसको चेक किया, नहीं उसमें तो स्टील लगा हुआ था। This is a new line that this reputed company has brought in. That disclosure should not be there. Is that we are replacing our steel bag with a thermocol bag for better efficiency, for better whatever. But that was a disclosure that they did not make anyway. एक लाइन बता था thermocol है चूहा खाया, they did not say anything of this. So thereafter it was on the buyer. आप disclosure नहीं कर buyer क्या हम जाके पिन लगा के फोड़ देंगे। और thermocol पेपर स्टिल remember that was thermal paper that was there, थोड़ा striking थे, and thermocol you would simply pin पूरे अंदर चली गई, and eventually we won. It was after that the company headed on the it was not multinational company, but they changed their assembly line. As soon as they filed that case, they changed it. जो नए उनके रेटल आने शुरू हुए, उसमें they brought in that steel back and they removed because subsequent they do कई साल बाद अभी हमने नया लिया था, वो भी उसी कंपनी के reputed company. And the first thing that I checked at the shop also was उसने देखे, ना क्या चेक किया, you don't know what that is. अब चेक क्या करना है, ना स्टील होता है, स्टील होने का जो भी था, अब उसको हम क्या बताते हैं, 15-20 साल पहले हम लोगों ने बहुत बार किया था। तो you know, so you have to pick the interest of the court. क्या है सर, courts are flooded with litigation. Always there are interests of the court. This is the trust. And if you get courts or any case you serve, just see the arguments of a designated senior. The designated senior बड़ा मुश्किल से बनता है। मेरे senior की यही आर्ट होती है as to how interest कैसा होता है। So just develop that. These are all monotonous things. Day in and day out for a judge. We got at least so far as my list is concerned, there are around 200 cases on that sort. And I tend to rush people. यहाँ trust होता है, जल्दी बताइए, not जल्दी because I see the litigant sitting at the back. So you have to pick the interest of the court. सर ये है और सॉरी दौरान ये है, अभी ये टेस्ट you have to remain abreast of the case. Be very humble, be very right. Be always true to your client. Client आए आपके पास साफ बता दें, आप कुछ है नहीं, वो सर sometimes the client से आप हमारे गुस्सा करना चाहिए। What we used to hear repeatedly, सर डॉक्टर और वकील का काम ही होता है, डॉक्टर का होता है मरीज बनना, लीडर्स पे कुछ नहीं बचा तभी वो सारा इलाज करेगा। वकील का काम नहीं होता है कुछ नहीं आपको फिर भी आपको करवा देगा। It is for you to decide. One of the few clients that I had were my clients who got attached with me at the very beginning of my career. And उनका service matters वगैरह जो भी matters वो खत्म भी हो गए. Despite that they continue to send clients to me. इसके बाद नहीं सही बात आपको बता रहा हूँ. नहीं है तो बहुत रवाना करें. One of the oldest clients of mine, oldest since the earliest clients of mine, एक पहला केस आया था कुछ नहीं वापस. दूसरा केस बता रहे हैं मैक्सिमम रिटायर होने वाले आने इसकी छाट के ये करेंगे कुछ फर्क नहीं पड़ेगा आपको रिटायर थोड़ी आपसे सेकेंड वर्मा लेके आ रहा हूँ पैसे दे रहा हूँ आपको क्यों नहीं करते मुझे आप कुछ नहीं क्या करेंगे अरे अल्टीमेटली 3 महीने बाद तो रिटायर कुछ हो नहीं तीसरा मुकदमा था ये स्टेटेड दैट वी वन एंड ही कंटिन्यू टू सेंड क्लाइंट्स राइट टिल माय एलिवेशन आई प्रैक्टिस फॉर अराउंड 22 इयर्स राइट टिल माय एलिवेशन ही कंटिन्यू सेंड ऐसा उनके बाद नहीं अच्छा और other lawyers with whom you are attached, the group of lawyers, always be true to your client, true to yourself, true to your conscience. I am अलग काम कर रहे हैं. I often tell the judicial officers who है, आपके अंदर एक conscience है, आपके अंदर एक ज़मीर है जिसको अगर आप उर्दू में कहेंगे, अंतरात्मा हिंदी में कहेंगे, conscience अंग्रेजी में कहेंगे. हर आदमी करता है, मैं सब करते हैं सबने क्या, मुझे को इन्होंने चार्जशीट कर दिया, मुझे को टर्मिनेट कर दिया, सारा आदमी फर्जी वाला करके आ गया नौकरी, मुझे निकाल दिया। मतलब ये तो वही होगा, कोई चोर पकड़ा है, 50 चोर नहीं पकड़ा, मुझे क्या पकड़ लिया, आप पकड़ लिए। They cannot be negative attitude Supreme Court को काम differently. You cannot हमेशा हो रही है, तो हमने कॉन्शियस रही, ईमानदारी से चलिए। इसी बात को एक और एनेक्डोट हम बता दें, क्योंकि इस उम्र में पहुंच चुके हैं कि आपको you tend to reflect back, ये तो दूसरे साथ पहुंचा भी जंग है, तो I tend to वापस लेने का है। My client's senior, sorry, my senior was a judge who retired from the Honorable Supreme Court. He taught my senior a thing कि भाई आप वकालत ना, लेकिन 2 लाइनें आपको दिखाई देने की लगी। एक वो होगी जो would adopt any means to become a senior or professional manager, adopt any means, any shortcuts. And those cases are ठीक है, long run है। The Robert Frost ने कहा था, I went to the forest, not exactly forest में गया, saw 2 roads, I took the road lesser traveled. Robert Frost की मुझे तो दूसरी लाइन हो गया, कुछ कम लोग क्या है, अपनी मेहनत करनी पड़ती है, कोई शॉर्टकट नहीं है, मुसीबत है लगे, तो that would be a shorter line. लेकिन shorter line in order to reach the top, it would take lesser time. राह थोड़ी मुश्किल, but it would take lesser time. लंबी लाइन तो सब लगे होंगे, बहुत लंबा हो जाएगा टॉप पे। My senior did that. He reached the Honorable Supreme Court, retired as Supreme Court judge. My senior retired as a High Court judge. And he had 3 juniors. The other 4 juniors, one of them died. The other 3 juniors of his are all now attending the bench of the Allahabad. I can tell you that for a fact. And incidentally, one of them was honored recently in the Lucknow bench. This is exactly what he indicated, that his senior told him. And he indicated the names of 2 others. And the other senior most, he indicated the name of 2 others. हमेशा, and this is on the 8 chambers से एक सुप्रीम कोर्ट निकलना और तकरीबन 4 हाई कोर्ट जजेस निकलना है, it's a very वो लोग भी जो चुका इनवाइट बायस है ना सीनियर कोर्ट इसी में एक और आपको किस्सा सुनाता हूँ। बहुत सारा रशियन, जैसे हमने कहा यार सेंचुरी रशियन, there used to be application, there was a member of the collegium subsequently on my division, कुछ दिन के लिए आवाज से बैठे, it was rushing through the application, but contempt application, implement application, implement allowed, one of our application was allowed, this is cited, yes, we are trying to implement a person who was not a party in the original petition. Arey how is that possible? This is another Supreme Court decision, bit all is different. Any person who stands as an impediment in compliance with the decision is liable to be implemented. I'll tell you the data. We got to Supreme Court, immediately. Next week was there. He stood up. Yes, implement application. Must have allowed it. We have tried to implement a person who not a party in the petition. And we have placed the land on the Supreme Court. Yeah, Supreme Court judgment, Mahendra Singh Bhatta, regarding the hard security date. Their judgment, I gone through the judgment and I allowed the application. So now, previously when that had transpired, there were a few designated senior secretaries, right in the dice. When I said इंसान को नहीं होगा कि वो तो देखना पड़ेगा, I was giving the dice, अरे बेवकूफ आदमी क्या करते हो? बोर्ड अलाउ नहीं क्या बता दिया हमने? अलाउ भी, मतलब बोर्ड ने हमारे भरोसे अलाउ, हमारे पेट हमने बात, हम सही चीज ना बताते ना, betrayed the trust that board placed in me. Never do that. Board trust you, always indicate it. हमेशा that would really help you अगर जो लोग as a lawyer join करें, and for that matter I've never been I've never opted for any services unless I've got any examination, but those are the things that शायद आपको सर्विस में भी काम नहीं, आप ईमानदारी से सही चीज हमेशा करिए, चाहे आप सर्विसेज में जाइए, चाहे अपने प्रोफेशन में जाइए, चाहे कॉर्पोरेट लॉ में लगेगा ये तो जरूर ये छोटी छोटी चीजें थी करते रहिए। आपके पेरेंट्स they sacrificed much in order to send you where you are sitting. This in colleges से आप आ रहे हैं, I think one of them, this is Lucknow University perhaps, and the Chandigarh University, all excellent colleges. Your parents are sacrificed, always try and see your parents smiling. जो भी आप करेंगे, parents should smile, should feel satisfied कि हाँ अच्छी आपकी तालीम दी, अच्छी तरबियत दी, तरबियत is your bringing up, your bringing up. Few things that I thought I should indicate to all youngsters, young blood. But confidence, excellent. Hats off to you, all of you. बहुत ही अच्छा all the best for your future endeavors. Be always respectful to your views. एक गुरु का छोटा सा और बताते हैं, बहुत atrocious handwriting, मतलब हम नोट्स बना रहे होते हैं दिखाने के लिए, अगर हमने उस दिन नहीं लिखा लिया, दूसरे हम खुद नहीं पढ़ पाते क्या लिखा। That is how my handwriting was. तो the school में हम थे, हमारे teacher थी, so she was very strict about the handwriting. Class 5, 6 and 7, one of the years she was a class teacher and then she was a subject teacher for English and mathematics subject. And she was very strict about the handwriting. किसी का नहीं handwriting, you get trapped on our methods. That time, those were the golden days of physical punishment teachers accepted. Anyway, I never got trapped. After my elevation, especially when to teach, obviously, which took class 6 would have been around 18, 19, 18. I went to meet her in 2017. Yes, Abdul, how are you? Now you would be no, so many. But for the handwriting, you must have got trapped on the numbers. I was one or two exceptional guys in my class who got never trapped on my letters, for my handwriting. So your handwriting must be beautiful. Then I might say, cautious. Even I can't read it. And now you want to beat him. So always be respectful to your gurus. जिन्होंने आपको बताया कि जिन्हें आपको मेहनत करते हैं, respectful to them also. Gurus, parents, जो litigation में आएंगे, बहुत सारे लोग आपके पास गरीब भी आएंगे, who can't afford anything. उनका भी देखिए. एक मुहावरा है, कटे जजमान सीखे नाऊ. बार-बार का लड़का जब आता है, नाई का लड़का जब आता है, कटे जजमान जो 3% उसका भी तो रहेगा तो कटे जजमान उनका 3 उस पे हाथ रवा कर दो ना, गाड़ी वाले हाथ कट गया क्या फर्क पड़ता है? कटे जजमान इसी माने नाऊ सीख रहा है, नाई नाऊ सीख रहा है, कटे जजमान आज बेस्ट ऑफ योर ability. Try to peace is not a problem necessarily. Don't run after money. After a few years, money will start running away. इतना आप अच्छा आपने वो करेंगे. These were the few words here, or the other word, but anyhow, excellent performance by everybody. I wish you all the best for your future endeavors. God bless. Thank you.
Thank you.
हो गया